Madam Registrar, would you please call the cases?
Yes, Your Honor. Good afternoon, Your Honor. This is the case number IT 0474I. The prosecutor versus Jadranko Prlić, Bruno Stojic, Slobodan Prlić, Milivoje Petković, Valentin Soric, and Berislav Pusic.
Thank you, Madam Registrar. May I first ask to all 6 accused whether they can hear me in a language they understand? Could I perhaps first hear from Mr. Prlić whether he can hear me in a language he understands?
Yes, I hear you. I rozumiem vas.
I do understand you.
Thank you, Mr. Prlić. Then Mr. Stojic.
Da čujem vas.
Yes, I can hear you.
Then Mr. Prlić.
Čujem I razumijem.
I can hear in a language I understand, thank you.
Same question for Mr. Petković.
Čujem I razumijem.
I can hear and understand.
Question for Mr. Ćorić.
Čujem.
I hear you well.
And then finally, you, Mr. Pusic, can you also hear me in a language you understand?
Čujem I razumijem.
I can hear and understand.
Thank you very much. By addressing you all, I take it that you also confirmed your identity, that you are Mr. Prlić, you are Mr. Stojic, you are Mr. Prlić, you are Mr. Petković, Mr. Ćorić, and Mr. Pusic. Then I'd like to have the appearances. We have already heard from the accused. Could perhaps first counsel present themselves. First counsel for Jadranko Prlić.
Good afternoon, Your Honor. I'm attorney at law, Chamil Shalahovic from Zagreb, representing Mr. Jadranko Prlić. Next to me is my esteemed colleague, Želimir Par.
Mr. Salahovic, Mr. Stojic is assisted by...
Good afternoon, Your Honor. I am Željko Olujic, attorney at law, defense counsel from the Republic of Croatia, Zagreb, representing Mr. Bruno Stojic.
Thank you. And may I invite counsel for Mr. Prlić to introduce himself.
Good afternoon, Your Honor. My name is Krešimir Krsnik. I'm an attorney at law from Zagreb, Republic of Croatia. I will be lead counsel for Mr. Slobodan Prlić. Thank you.
Thank you, Mr. Krsnik. Then could counsel for Mr. Petković present herself?
Your Honor, good afternoon. I'm attorney at law, Vesna Alaburic. My head office is in Zagreb, Croatia. I will be defending General Milivoje Petković.
Yes. Then Mr. Ćorić is assisted by...
Dobar dan, časni sude.
Good afternoon, Your Honor. I am Tomislav Jonjić, attorney at law from Zagreb, defense counsel for Mr. Valentin Ćorić.
Thank you, Mr. Jonjić. Then finally, I'd like to invite counsel for Mr. Pusic to introduce himself.
Dobar dan, čast.
Good afternoon, Your Honor. I am Marinko Škobić, attorney at law from Mostar, Bosnia and Herzegovina. I will be representing Mr. Berislav Pusic.
Thank you, Mr. Škobić. May I have the appearances for the prosecution?
Good afternoon, Your Honor. May it please the court, appearing on behalf of the prosecutor, Kenneth Scott, senior trial attorney. With me today are trial attorneys Peter Kruger, Garlon Egels, and Miguel Wangone, and our case manager, Ms. Lakshmi Wapita. Thank you.
Thank you, Mr. Scott. Then the only anonymous person at this moment is am I myself. My name is Judge Ori. I am a judge in Trial Chamber 1. The cases against all 6 of you have been assigned to Trial Chamber 1, consisting of Judge Liu, Judge Amadi, and myself. And Judge Liu has assigned me as pre-trial judge in your cases. These decisions have been taken yesterday. I don't know whether the defense counsel have received already copies of it, but they're available for them. Could I first ask the assistance of... I have a Zoom in my... Yes. Direct is better. This is better, so now I don't hear anything at all. I'm just testing. Well, I'm testing my earphones. All yours are functioning, but mine is still not. A noise. If I do it here, I've got nothing at all. Nothing at all? No. This one. Just 4, channel 4. I don't hear anything at all. Oh, perhaps now it's better. No. I'm trying to... is it channel 4? Don't hear anything on channel 4.
Channel 5? Yeah.
This is... don't hear anything at all. I'll take this one. I'll take this one. I apologize for the delay, but I have some additional noise in my earphones, but that shouldn't be a major problem. Having introduced myself, I'd like to explain to you what the purpose of this initial appearance is. Article 20, paragraph 3 of the statute informs us that I should read the indictment to you, that I should satisfy myself that your rights are respected, and that would specifically mean at this moment that you're informed about the charges that have been brought against you, that your right to be assisted by counsel is respected. Then I have to satisfy myself that you understand the indictment, and I should instruct you to enter a plea. That means that you enter a plea of guilty or not guilty. Since you arrived only yesterday in The Hague, the rules of procedure and evidence give you an opportunity to enter a plea within the next 30 days, but if you want to enter a plea today, you are allowed to do so. So I move to the first part of Article 20 of the statute, and I have to satisfy myself that you're assisted by counsel. And now I address counsel. I was informed that you're not assigned by the registrar, but you're all counsel of choice by the accused. Do I have to understand this choice as being a choice on a more permanent basis, or is it mainly for this initial appearance that you'll assist your accused? Could I hear that from each counsel? Perhaps first, Mr. Salahovic.
Your Honor, maybe I can answer. On behalf of my colleague Mr. Salahovic and myself, our client authorized us to represent him on a permanent basis. We know that there is no authorization that is full guarantee that will remain till the end, and we don't know the stance of the registry for the time being concerning our engagement.
Then Mr. Olujic.
Thank you, Your Honor. What I can say is that it was the will of my client that I should represent him as his defense counsel, and that implies a permanent basis and the trust that my client has in me, and in keeping with the letter and spirit of the statute and the rules of procedure prevailing in this lofty court, I think there should be no problem, because the underlying intent is to protect the fundamental rights of the client, including his right to a defense.
Mr. Olujic, did you discuss with your client that you are assisting at this moment, Mr. Rajic, who is accused before this tribunal?
Yes, Your Honor. Even before I undertook the defense of Mr. Bruno Stojic, I discussed with my other client, Mr. Ivica Rajic, who is currently involved in proceedings before this tribunal, and he unconditionally accepted that I should also defend Mr. Bruno Stojic.
Are there no conflicting interests between your two clients, Mr. Olujic?
No, Your Honor.
Is it true that the indictment against Mr. Rajic very much focuses on the Varus municipality, and that the Varus municipality and what happened there also appears in the present indictment against Mr. Stojic in paragraph 204 and the following?
You are right, Your Honor. The indictment against Mr. Bruno Stojic refers to stupni do inter alia. However, when we read the indictment and take into account the scope by which Mr. Bruno Stojic is encompassed in the view of the prosecution and the role that my client had, we see no points of contact and no reason for any conflicting interests between these two clients, Mr. Ivica Rajic and Mr. Bruno Stojic.
Isn't it true that Mr. Stojic is held responsible for acts for which Mr. Rajic is charged as a perpetrator?
Generally speaking, yes, because that is the way the indictment is worded. But the very position in the hierarchy that my client held had no points of contact with Mr. Ivica Rajić. Mr. Stojić was never in a position to command any troops of police forces, army, or other forces, whereas Mr. Rajić is a military officer of the Croatian Defense Council.
From what I understand from the indictment, Mr. Stojić is held responsible not only for non-military, but also for what happened militarily on the ground. Let's not pursue this matter in full detail at this very moment, although the question of whether a direct command contact is the criterion to be applied is unclear to me at this very moment. I heard your submission in that respect. Let me ask you, Mr. Stojić. I take it that you were aware of Mr. Olujic also defending Mr. Rajić, who is charged with the events, especially in the Varus municipality, for which you are charged as well.
Your Honor, I insist on being defended by Mr. Željko Olić. He was my choice, and I will be as emphatic on keeping him as my counsel as I can.
Mr. Stojić, I do understand that for this very moment, where there's nothing more asked from you to enter a plea which I don't know what it will be, but can always be, if it will be a not guilty plea, it can always be changed. Of course, the other way around would be more difficult. You can't plead guilty now and plead not guilty tomorrow. I ask you to keep that clearly in mind, and where you say that you insist on being defended by Mr. Olujic, I have to inform you that the Defense Council are bound by the regulations established by this tribunal, and that it depends on those regulations whether your wish, if I may interpret that way, finally can become true. But I do understand that you're fully aware of the present situation of Defense Counsel defending two accused involved in charges regarding the same events, but from a very different position.
I can only repeat that I insist on being defended by Mr. Željko Olujic. I have discussed with him over the last 4 or 5 days, and we touched upon this subject as well, and still I insist on having him as my defense counsel.
I do understand that it's your specific wish to be defended by Mr. Olujic. Then for the Mr. Prlić, you are aware that Mr. Parr has defended Mr. Martinovic before this tribunal.
Yes, Your Honor. I am informed about that. I have discussed this with my counsel, Mr. Parr. He said that the matter will be resolved following due procedure with the competent authorities of this tribunal, primarily the OTP, and I believe any conflict of interest will be avoided.
Then, Mr. Prlić, you are aware that your defense counsel, Mr. Krsnik, has previously presented Mr. Naletelic in this tribunal.
I am aware of the fact, Your Honor. And if there is no obstacle in the rules of this tribunal, I have already testified before esteemed Mr. Scott here, and I wish to say that if there is no obstacle in the rules, then I would like to keep Mr. Kršnik as my defense counsel.
From the fact that I did not ask any specific questions, you could conclude that at this moment no specific circumstances came into my mind that might indicate that there could be a conflict of interest. Then finally, I have Mr. Bauer, Mr. Kršnik, if you would like to make observations in this respect. I have no specific questions. Please do so.
Your Honor, maybe I should say just a few words. Before I got involved in the defense of Mr. Prlić, I had discussions with Vinko Martinović, my client, and received his repeated consent to my engagement as defense counsel for Mr. Prlić. Mr. Kršnik. Your Honor, I have no particular comment, considering that Mr. Scott and I have spent in this courtroom almost 2 years. I don't want to take any more of your time. I have no particular comments, and I believe there is no conflict of interest. Thank you.
Yes. Then, Mr. Prlić, a similar question in respect of you. You are aware that your defense counsel, Mr. Jonjic, defends at this moment Mr. Ljubicic before this tribunal. Mr. Ljubicic, who is charged with crimes that allegedly were committed in the same period, but not in the same villages and municipalities. But I could not, just by reading the indictment, exclude any relevant overlap in, for example, command structures. You are aware of the fact that Mr. Jonjic represents Mr. Ljubicic?
Your Honor, I am aware that Mr. Jonjic is defending Mr. Ljubicic. We believe there is no conflict of interest. Thank you.
Mr. Jonjic, is there any submission you'd like to make here? I have no specific questions apart from the observations I just made.
Your Honor, I believe it is useful just to mention that Mr. Ljubicic was informed in due time of the possibility that I would appear as lead counsel for Mr. Ćorić, and he gave his full consent. And in view of the fact that you emphasized, namely, that events for Mr. Ljubicic is charged are not covered by this indictment, we believe there is no conflict of interest. However, it is up to the registry or the tribunal, rather.
Thank you, Mr. Jonjic. I just want to make quite clear to both you, counsel, and accused that from the mere fact that we will now continue, that you could not conclude that there's a final determination by the chamber or by me as a pretrial judge that conflicting interest that would prevent you from acting on behalf of one of these accused are absent. It is a question which specifically in respect of counsel and accused I just addressed is still open. There's no final determination on that. Then may I ask each of you whether you have read and discussed the indictment brought against you with counsel. Mr. Prlić, did you?
Yes, Your Honor, I have. I understand why I am charged by the indictment, although I did not understand the underlying charges. If it is necessary to say it in so many words for the record, I am saying now that I have received and understood the indictment.
And same question for you, Mr. Stojic, whether you received and you have read and discussed with counsel. These are three questions: whether you received it, whether you read it, and whether you discussed it. The indictment.
I have received the indictment, I have read it, and discussed it.
Mr. Prlić, same question for you, or the same three questions for you.
I have received the indictment, Your Honour. I have discussed the indictment with my defence counsel, and on a logical level I understood the indictment.
Yes, you also read it? Yes. When I ask you whether you read it, it is presumed that you received the indictment in your own language. If that's not the case, please inform me. Then, Mr. Petkovic, for you also the three questions: whether you received it, whether you read it, and whether you discussed it with counsel.
Your Honour, I have received the indictment, I have read the indictment, I have received a copy in my own language, in as far as it could be in my own language, and I have discussed the indictment with my defence counsel. I understand what it says.
Thank you, Mr. Petkovic. Mr. Ćorić, same three questions for you.
Your Honour, I've received the indictment, I've read the indictment, and I've discussed the indictment with my defence counsel. Thank you very much.
Thank you, Mr. Ćorić. And finally, Mr. Pusic, you're always the last, but same three questions for you.
Your Honour, I have understood the indictment, I've received the indictment, and I have discussed the indictment with my defence counsel. There are a lot of things I didn't quite understand in view of the fact that I was involved in humanitarian issues during the war. Thank you.
Yes, but the lack of understanding was not caused by the language of the indictment, but rather on that you could not understand how you could be charged as you were charged.
I understood the language of the indictment, but there was still quite a number of things of which I stand indicted that I failed to understand.
Yes, but do you fail to understand what you're charged with, or do you fail to understand why someone could decide that it would be fair to charge you with these counts or these facts?
As I was involved in humanitarian work, there are quite a number of things that I hear now for the first time. I was never physically present there. That is why I was surprised to find myself indicted of these things.
Yes, now I better understand what your non-understanding actually means. If you'd prefer to remain seated, then I will not feel in whatever way offended by it. So if that would be more comfortable for you, please remain seated as you wish.
Thank you very much.
You have all read the indictments, and unless one of the counsel would disagree that he discussed it with his or her accused, I take it that the indictments were discussed with them. There's, however, one issue which is not entirely clear to me. Did you receive, and I'm now addressing counsel, did you receive any of the annexes to the indictment?
Your Honor, Jadranko Prlić's defense has received all the annexes and attachments to the indictment, some of them today.
Yes. Is that true for, could we do it another way? If counsel did not receive the annexes, I'd like to hear.
No need for me to speak then, Your Honor.
Then a question for the accused. Did you read also the annexes to the indictment, and were you able to discuss them with counsel? If any of you had no opportunity to read or discuss it, I'd like to know. Perhaps first, Mr. Prlić, if you...
Your Honor, I don't understand what annex means. Is this to do with technical issues in relation to the law? In that case, yes, I have received those.
No, it has got nothing to do with the law. As a matter of fact, attached to the indictment, one single indictment against all of you, in annexes the identity of victims, whether killed or wounded or sexually abused, is given in relation to the locations where the crimes allegedly had occurred, and further details are given in respect of sniping incidents in Mostar. I see some confusion. Mr. Parr.
Your Honor, I said before that we have received all these annexes without even knowing that there were any such documents to be attached to the indictment. When I said that we had everything, what I had in mind were the usual technical attachments to an indictment, the kind that we usually have. What you're telling us now, I can only say that our defense has not received any such documents. I don't know about the other defense teams, but probably my colleagues would have informed me of receiving any such documents. By your leave, Your Honor. First of all, when my client received the indictment, there were no attachments, no annexes, just the text of the indictment itself in both Croatian and English. Having arrived in The Hague, more specifically today at 1400 hours, we received some of the documents of procedural nature. The arrest order and so on and so forth. I do not want to go now into enumerating all the documents that I've looked at half an hour ago, but what you have just told us about, Your Honours, we have so far not received any of those. I'm not sure about the other defence teams.
I can imagine that you didn't receive it, although it appears from the indictment itself that there should be annexes. For example, if I draw your attention to paragraph 106, you'll see that a reference is made to annex. I also can understand why you didn't receive it, because they are still under seal and confidential. I did, however, understand, Mr. Scott, that the prosecution would not insist on keeping them under seal, but that they should remain confidential.
May it please the Court, Your Honor, you're absolutely correct. As you just indicated, the indictment on its face indicates that there are annexes, confidential annexes attached as part of the indictment. The situation that we confronted was that there was certain information that was very sensitive, identifies particular victims and potential witnesses by name, and until such time as the accused could be brought before the custody of the tribunal and such protective measures ordered by this chamber, we were not in a position to be able to make that information available to the accused. This was all previously addressed with Judge Antonetti, and as you pointed out just now, Your Honor, the annex themselves had remained sealed. Further, as Your Honor just correctly stated, the prosecution has no interest whatsoever in keeping that information from the accused, and in fact is prepared to provide that information today, provided that protective measures are entered, and the prosecution would be satisfied if Your Honor could make oral rulings or orders to make it very clear to the accused that the annexes would be provided in the strictest of confidence, not to be disclosed for any purpose at all to any other person other than the immediate defense teams, unless and until other court orders might be entered. If Your Honor is prepared to do that, and we could proceed that way if you wish, we're in the Chamber's hands, we'd be happy to do so.
Yes, please, Mr. Mr. Parr.
Your Honor, before we continue, I would like to have an explanation, please. These annexes, what exactly do they mean? Are they part of the indictment, an integral part? Are they an integral part of the indictment, or something outside the indictment itself? If those annexes are part of the indictment, if they're considered part of the indictment, in that case, I'm afraid I must say that our clients have not had a proper chance to look at the indictment. I hope the Chamber can assist me with this. Just another thing, briefly. In the indictment itself, there's a reference to a number of annexes. This was supposed to be the kind of warning to the defense that there were more documents to be had. We do not believe that the defense should be put in a position to beg the prosecutor for more documents concerning the indictment itself. The fact that there were annexes means nothing to us before we've had a chance to look at those and be in possession of those documents. In relation to the proposals made by Mr. Scott, I have to say that as an attorney at law, I simply do not understand whether these annexes are part of the indictment or not.
Yes. Before I give an opportunity to other counsel to address the matter, perhaps I should give you a little bit more information. The lifting of the confidentiality by Judge Antonetti did not include the annexes. Let me first of all explain to you exactly what these annexes are. These annexes, it's one annex, several parts. In these annexes, details are given about the identity of persons killed, wounded, or sexually abused related to the various locations. So you'll find there in this location the 2 people killed, names are X, Y. And then in the annex also some additional details are given in respect of the sniping incidents that took place in Mostar. That means name of the person involved and where it happened and what kind of weapon was used. I see that you're standing, Mr. Prlić. Is there any specific reason, or is it just to overcome some uncomfortable being seated?
Your Honor, if I may, I have some health problems. As you can see, I'm on crutches. I can't sit down and I can't stand up.
Yes. If you're not able to follow these proceedings being present here, I'd like to hear either from you or from counsel.
Your Honor, if I may explain briefly, my client had undergone a very complicated spine surgery last week at his own risk. He left the hospital despite being cautioned by the doctors not to leave. He responded to your call to receive the indictment, and in view of the medical recommendations he received, he should be able to follow the proceedings here, be seated for perhaps 15 or 20 minutes at a time, but after that he has to stand up to relax a bit, because that's what his spine, the condition of his spine requires. Therefore, I would ask your permission for my client to stand up occasionally from time to time for that reason.
Mr. Prlić, just take the position which is most comfortable to you, although I do understand that all positions are uncomfortable, but take the best one, and whenever you feel that you'll not be able to follow these proceedings here because of your medical condition, please inform me. Then I'll return to where we were, and that's the annexes. I said that a piece of information is also contained in this annex relating to details of specific sniping incidents in Mostar. Sniping incidents which you find, let me just check, I think in well, it's somewhere in 24, 25 or 26 of the indictment that specifically the sniping incidents are mentioned, and you'll find further details about these incidents. Of course, I've given it some thought prior to this hearing whether we could proceed, and apart from that, I'd like to hear from you whether, without having seen this, or if you prefer to have a short break to read it, if I would have given an order that the seal is lifted. I came to the conclusion that it very much depends on what the accused intend to plea. Since if you enter a plea of not guilty because you say that you are no member of the joint criminal enterprise had not these purposes, did not even exist, people were not killed, then of course it might not be of major importance to know exactly whether Mr. X or Mrs. Y or child Z was not killed, if you deny the killing at all, or if you deny responsibility for the joint criminal enterprise or another form of participation in that killing. So therefore, the absence of knowledge, of course, gains great importance if there's any intention to enter a guilty plea, and might have less importance if there is an intention to plead not guilty. On the other hand, I'm willing, having heard the observation of the prosecution, I'm willing to just take a break for 10 minutes after having given an oral ruling, after you have been provided, I don't know, in all languages, Mr. Scott?
Yes, Your Honor, they can be provided in both English and in Croatian.
Yes. So I'd now like to hear from you what you'd like to do, to say no with the lack of knowledge of these annexes. We could not proceed today, then fine, we'll stop, we'll give a ruling on whether the annexes will be provided to you, or whether you say we would like to proceed, but not until we have had an opportunity for 10 minutes at least to get an impression of what's in those annexes, of in that annex, or that you say, since our clients intend to enter a plea of not guilty, it's of no major importance anyhow to know what details there are on events that we deny to have taken place at all. Could I please hear first from Mr. Parr of Mr. Salahovic, or if you want to confer first.
Your Honor, we cannot take this decision without first conferring with our client. Therefore, my proposal is, let us have a short break to consult our client and the other defense teams to look at the documents and then come back to the courtroom to give you our final position. Thank you.
Is this a position shared by all defense counsel? I see nodding apart from you, Mr. Prlić.
Yes, Your Honor. Yes, Your Honor. I agree as well. By way of introduction, I wanted to say that I do not oppose the idea of a break now, but what seems to be beyond doubt on the part of the prosecution, and thank you too, Your Honor, for the clarification you have provided. It has not been challenged that these annexes are a part of the indictment, an integral part of the indictment. Therefore, I would also like to have 10 minutes to consult with my client. Your Honor, if I may, my client is seeking permission to address you, Mr. Prlić.
Mr. Prlić.
Your Honor, we have had a discussion among ourselves. I believe our plea will be the same for everyone, not guilty. If I understand Mr. Scott correctly, there is a possibility to inspect these annexes, and then the prosecution opposes a request for provisional release. If that is indeed the case, even before we've had a look at the documents, we would like to have at least 10 or 15 minutes, a break, to confer with each other and to see what we do next. Thank you very much.
Well, provisional release is not an issue that has been raised until now. So what I suggest at this very moment, but I'm also looking at security, whether it would be possible that counsel confer briefly with their clients in the courtroom during a short break. I would say 5 to 10 minutes would be enough to just read the annexes, or at least get an first impression, and then confer with your clients. May I ask? But before having a break, of course, I should give an oral order. The oral order I give at this moment is that the annex to the indictment will be unsealed but remains confidential. That means that defense counsel and accused are not allowed to communicate with anyone outside your defense team. I don't know whether you have already given a list of the members of your defense team to the registry. If not, then it means that it's only you, that means 7 counsel and 6 accused, who have access to this document that will be provided to you after this order by the prosecution. We'll then have a short break of until 3:15 and see how we will proceed. We'll have a break for 10 minutes.
All right, very full of